Hello, practical law students, and welcome to the second of two lessons on the juvenile justice system. Now, in the first lesson, we talked about the history of the juvenile system, the fact that communities were concerned that the failure of families was causing kids to act out in certain ways, and the courts kind of had to step in and take the role of parents. We talked about this tension that continues to exist, the dual roles of rehabilitation versus punishment. Okay. And the pendulum keeps swinging back and forth. In the 1960s, we thought we were too harsh. Then the 1980s and 1990s, we thought we'd become too soft. We talked about the age of 18, where typically when you turn 18, you move into adult court. Okay. But there are exceptions to that if the prosecutor can show both the criminal act and the motive, it is possible that even a juvenile could be tried in an adult situation. We talked about the changes, the new research that's coming out, that your brain continues to develop up into your 20s, okay, including the part of your brain that deals with peer pressure and impulse control and things like that. So that maybe we need to look at the punishment side of things, not so much about where we're going to try juveniles, but maybe look at the punishments that are out there. So that was kind of in lesson number one. Today, in lesson number two, where we're going to pick up are the procedures in juvenile court. Okay. Once again, as you go through, please be sure you are taking down your own notes. I will tell you what I want you to get down on each slide to try to make that easier. Also, don't forget, both sets of kids, the hybrid students and the online students, need to be doing this. We will not be covering these lessons in class. Okay, so be sure you're doing this on Canvas. And then there is going to be a graded assessment, a little worksheet that you can use your notes on once this is over with. So that's why I say please be sure you're taking notes so that you can do that little worksheet here at the end of these two lessons. Okay, so today our focus is going to be the procedures in juvenile court. Now, on this slide, you do not have to take anything down. Okay, you don't have to take anything down on this first slide because the exact procedures vary from state to state, but there is a general process similar throughout the country. Okay, so we're going to talk about big picture ideas as we move through these slides. The first thing that happens is the suspect must be taken into custody. All right, and the same reasons that the police might arrest an adult exist for juveniles as well. Even those status offenders, okay, those people that are just behaving badly, it's not necessarily a crime, but especially if they committed it while they were adult, even those status offenders can be taken into custody. Okay. That being said, the police have a very broad authority when it comes to releasing and detaining juveniles. Okay. At several points in time during this phase, juveniles can be released. Okay. Also, they can continue to be detained because of this broad authority. For minor offenses, police may give the juvenile a warning, okay, and release the juvenile to his or her parents very quickly, okay, or they could refer the case to a social service agency, all right, after giving a warning and releasing the juvenile to their parents, okay. More serious offenses or prior records, the police may detain the youth and refer him or her to juvenile court. Okay, so you could be held in custody and then sent to juvenile court. All right. Now, there are a couple terms that I want you to know for taking into custody. Number one is intake. Get down this term, intake. Intake is the informal process by which court officials or social workers decide if a complaint against a juvenile should be referred to juvenile court. Okay, so there's questioning that goes on, and then the ultimate decision is, do we proceed down the road to juvenile court with this? That's ultimately what is happening with intake. This informal process is based on interviewing the youth, considering the seriousness of the offense, the youth's past record, and his or her family situation, as well as other factors. All right. So in the course of questioning, these are things we're looking at. All right. The seriousness of the offense, past record, family situation, etc., etc. The other term I want you to get down, be sure you get this down, is diverted. Okay. Instead of going to juvenile court, the case is diverted and the youth receives educational services and treatment services. Okay. They do not go to juvenile court. the case is diverted and they go to other services, educational or treatment. Okay. So let's say we go through the intake process, okay, and the case is not diverted. We move to the next step. All right. The next step, after being taken into custody, going through that initial questioning, the next step is the initial or detention hearing. All right. And again, you don't have to copy anything down on this slide. We'll talk about a couple things on the next slide. Okay. Young people who are taken into custody and formally referred to a juvenile court. Okay. So after this intake process, the case is not diverted. We're moving on down the road. They go to an initial hearing. All right. The state must prove that an offense was committed and there is reasonable cause to believe that the accused committed it. Okay, so we've seen similar things to this in adult court. Okay, you have to prove that a crime has been committed and that the person in question or the person in custody did it. Okay, well, the same thing happens with juvenile court. If it is decided yes, the offense was committed, and if it was decided yes, the person in custody did commit it, if further detention is needed, the state must prove that the juvenile is a danger to himself or herself or others, that they are likely to run away if released, or there's been a past record that warrants detention. Okay, so we've determined the crime has taken place. We've determined this person has done it. Now we look at things like, have they done something before? Are they a danger to themselves or others? Will they run away? Here's where we factor in family history. Okay, what is the family going to do in this situation? Usually an attorney is assigned at this time if needed, okay, and a date is set for hearing on the facts. Okay, so we move to the next step, which is you're going to juvenile court. It is possible that the juvenile could be released to his or her parents or other adults at this time. It is also possible that they could be detained in a juvenile setting until the trial happens, okay? In a juvenile detention setting until the trial happens, okay? So that's what happens during this initial hearing is we got to decide, did a crime occur? Did this person do it? And then where are we going to put this person until the trial happens? Okay. Now, there are a couple terms with this that I want you to get down. This is what I want you to get down. Number one is preventive detention. Preventive detention protects the community and the juveniles themselves from the consequences of future crime. Okay, so if you're going to run away or you have a previous record or something like that, the judge may say that the juvenile is better off in detention than in his or her home. If you don't have a stable home situation, like your parents are going to be abusive or your parents are going to let you run away, okay, the judge might say you need to be held in preventive detention until the trial. Okay. That being said, and I want you to be sure you get down this, and we talked about this with lesson 1, if the child is put in preventive detention, they must be held separately from adults accused of crimes, okay? They have to be held separately. And we talked about that. That was part of that Justice Department Act that allowed for this to happen, okay? So at that initial detention hearing, this is something that is taken into account. All right. We're going to protect the community and the juvenile themselves by putting them in preventive detention. And if we do so, they have to be held separately from adults. Now, the next step, all right, and I'll tell you what I want you to get down here, is an adjudicatory hearing. Okay. All right. An adjudicatory hearing. At this hearing, the juvenile is charged with a delinquent act. Be sure you get that down, okay? The juvenile is officially charged with the delinquent act. So we had that initial hearing. We said the crime occurred. This person did it. Now we move to this hearing, and they are officially charged. And remember, we talked about this with the previous lesson. They have to be confronted with the charges against them. All right, so that's what's going to happen at this adjudicatory hearing. All right. This is a fact-finding hearing. Its purpose is the same as an adult trial to determine the facts of the case. All right. It is generally closed to the public. Be sure you get that down. Okay. So it's where the juvenile is charged with a delinquent act. It's a fact-finding hearing, and it is closed to the public. Be sure you get that down. It can still be covered by the newspapers, but in that case, the names of the accused and the details of the offense are withheld from the press. Sometimes you will have a jury depending on the state. Sometimes the state will allow for a jury in this case. Okay. You are entitled to representation by an attorney. We talked about that. Juveniles are allowed to have an attorney present. In fact, we talked about they have to be represented at all these hearings. Okay. And it varies by state to state what is allowed. The attorney can examine and cross-examine witnesses in an effort to force the prosecution to prove its case beyond a reasonable doubt. All right. It is just like a trial. And we said that is a right protected by juveniles as well. They have the right to confront witnesses against them and question witnesses against them. Okay. So everything that we're seeing here is mirroring sort of what we see in adult court as well. Okay. Now, here we go. At this hearing, if the judge finds the juvenile non-delinquent, which means non-guilty, he or she is free to go. Be sure you get that down. Okay, be sure you get that down. If the judge decides the juvenile is not guilty, he or she is free to go. End of case. If they decide that the facts warrant another trial, we go to the next stage. If the judge decides the facts are set out in the petition are true, the court enters a finding of delinquency. It's the same as conviction. Okay, and we move to the next step. All right, but if the judge determines the juvenile is non-delinquent, not guilty, he or she is free to go. All right. Now, if it's determined that yes, they are guilty, we move to the dispensational hearing. Okay. This is the most important stage in the system for juveniles who are found delinquent. Get this term down. A disposition, okay, or disposition, is a sentence. It is based primarily on the predisposition report prepared by the probation department. Okay, that's that fact-finding report. It's based on the investigation of the juvenile's social, psychological, family, and school background. All right, so the disposition is the sentence. In that disposition, it is supposed to provide for individual treatment geared toward rehabilitating the offender. That's why this is so important, okay? Because your background determines your punishment. Get down this next point. We have to balance the needs of the offender against the obligation to protect the community. And we have talked about that with adult court as well. This tension between you want to protect the rights of the accused, you want to protect the rights of the criminal, but at the same time, you have society you also have to protect as well, okay? Well, we see that here in the juvenile system too. You got the needs of the offender versus the obligation to protect the community. And we got to try to strike a balance with that when we move into the punishment phase. Options include probation, community service, okay, fines, restitution payment for damages. We talked about that. Placement in a community treatment program, or commitment to a state institution. All right. So we got all these options in order to try to balance the needs of the offender against the obligation to protect the community. Now, get down this. In most cases, probation is the most common disposition out there, but you have to meet certain conditions. Okay? You have to meet with the probation officer on a regular basis. If you don't meet the conditions of probation, you're going to be sent back to court for another hearing. You could be sent to a group home or state institution as part of the probation. In more serious offenses, you could be committed to a juvenile institution where your time is going to vary from 1 to 3 years. Now, in all honesty, most do not serve the maximum sentence, okay? But your exact time of release is usually determined by the agency that operates the institution. And it will depend on your behavior, depend on space available, et cetera, okay? So the only thing you need to get down on this slide is that first statement there. Probation is the most common disposition out there, but you must meet certain conditions, okay, to have that. disposition available. When it comes to the dispositional hearing, one of the main problems is overcrowding in juvenile facilities. In fact, that's why probation is often offered. Get down that point right there. One of the main problems is overcrowding in juvenile facilities, which helps explain why probation is such a big option. When released, we must consider the individual in light of the community protection. Again, we have to have that balance. We want to protect the individual, but we also want to protect community. Excuse me. We take into account offender accountability. We take into account the development of life skills, okay, that will enable the offender to experience success after he or she is released from the juvenile justice system. There are all kinds of factors that we take into considering the punishment phase as we move forward in the juvenile justice system. Okay, keeping in mind that overcrowding is a main problem. Okay, and we talked about that in adult court too. There's overcrowding in prisons as well. That's going to be a major problem. Now, we had all these hearings, fact finding. We had the trial itself. We've had the dispositional hearing where we're dealing with punishment and things like that. Now we move into the post disposition period. Most states give young people the right to appeal decisions of a juvenile court, but that provision is going to vary greatly from state to state. Okay, so kids do get the ability to appeal decisions made by juvenile court. Okay, now here's where I want you to get down on this slide. After being released from an institution, a juvenile may be placed in aftercare. Okay, that is the equivalent to parole in adult society. And we talked about with probation, you're going to have to do things like you're going to have to meet with a parole officer, et cetera, et cetera. Okay, you're also going to have to commit to things like education. You got to be at school. If you're working, you got to find a job, or you might have to find a job. Okay, or do some other form of vocational training. All right. So aftercare, there's a lot of stipulations with it, but this is one of those things we're looking at the rights of the accused, okay? Because we want them to enter back into society, and we want them to enter into society in a better place than they were before. So a lot of the stipulation with aftercare is we want kids to go to school, we want them to get an education, we want them to get a job, we want them to go to vocational training, something like that, so that whatever they did before, they move away from, okay? I like to think of it this way. You're too busy to think about doing something wrong because you're in school, you're at work, whatever. Okay. The other thing I want you to get down is the last point here, reentry programs. Okay. Just like there are reentry programs for adults, there are reentry programs for juveniles as well. All right. Especially to help with the transition back to school. Okay. If you've been in a juvenile detention center and you've been going to school in that juvenile detention center, that's going to be different from going back to a public school. Okay. So we have these re-entry programs to help transition juveniles back into society. Okay. And that transition to school particularly is difficult for juveniles, all right, more so than adults, okay, because adults are probably not dealing with school and things like that. Of course, we know how information spreads in school. People probably know where you've been and what's been going on and things like that. So it's a very, very difficult time. So these reentry programs are key to helping juveniles transition back into society after leaving the juvenile justice system. Now, if you're in the juvenile justice system, you do have a record. So the last two slides here are going to have to deal with having a record. Okay. If you're found delinquent, okay, you don't necessarily have a criminal record. Okay, especially if you found delinquent but the judge let you go, you don't have a juvenile record. Be sure you get that down. So if somebody asks you, did you commit a crime? Since you have no record, you may legally say you weren't convicted of a crime. Okay? All right? You weren't convicted of a crime. You don't lose any civil rights. You can still register to vote. Okay. Some states allow some or all information on juvenile cases to become public, so employers could access it. All right, but you can still say, I don't have a criminal record. All right. Sometimes it comes up, like we've talked about with repeat offenders. If you continue to commit crimes and you become an adult, sometimes the juvenile record might be brought into court. All right. I want you to get down this last piece. In a few states, juvenile records are automatically sealed or expunged, which means destroyed, when the juvenile turns the age of either 18 or 21. It's considered having a clean slate. Okay, so in some states, your record is sealed when you turn 18 or 21 and nobody can access it. All right. So the whole point we're saying here is, and I should have made this more clear at the beginning, you don't have a criminal record. Okay, you don't have a criminal record. You do still have a juvenile record, which is why if somebody asks you if you've been convicted of crime, you can legally say no, okay, because you've been found delinquent. You haven't been found guilty, you've been found delinquent. But you don't have a criminal record, okay? Now, I do want you to get down everything on this last slide, okay? When it comes to having a record, in most states, get all three of these points down. In most states, the record continues to exist unless the person, who is now an adult, officially requests that his or her record be expunged, okay? So in a few states, it will automatically be expunged. In other states, you have to ask, okay? Before the record will be expunged, several years must have passed since the offense, okay? And during that time, you cannot have committed any other offenses. All right. So before your record will be sealed or it will be expunged, the judge will look at these two things. How many years have passed? And then have you kept yourself clean during that time? Okay. And chances are, if it's been a number of years and you haven't been found guilty of anything else, you haven't had any other trouble or anything like that, your record will be sealed or expunged, completely destroyed. All right. But you have to ask for it in those states where it's not automatically done. All right. So that's the juvenile justice system real briefly. Okay. Be sure you go back. Be sure you have notes down that you've taken the things that I've specifically told you to take down. Be sure you have those ready to go. And then you have a little written assignment, got a little worksheet with some questions to answer based on these two lessons. And it is graded. So be sure you get that in by the end of the week.